Okay, so we continue. This is Wayfarer's opposition to Lively's motion to exclude the testimony of their defense rebuttal expert, Anne Fromholz. Anne Fromholz is, so she's a workplace investigations expert, and she is brought in to rebut the testimony of, oh my God, the asshole that Lively has retained, Michael Robbins. Oh, I cannot stand that guy. He's so arrogant and rude. Okay, yeah, the guy who shreds his notes. That I can't get him out. I can't even get over that he did that. But okay. Okay. Introduction. Blake Lively moves to exclude defendant's rebuttal expert Anne Fromholz. For many of the same reasons, defendants move to exclude Robbins, including lack of relevance, improper legal opinion, and lack of qualifications. In doing so, Lively conveniently ignores that the same principles should apply to Robbins, resulting in the exclusion of his testimony as well as Fromholz's. Interesting. So what Wayfarer are basically saying here is, look, for the same reasons that Lively is trying to exclude our expert, we sought to exclude her expert. So, effectively, if Fromholz is not allowed to testify, then Robbins should also be excluded too. It's a good argument. Okay. If the court grants defendant's motion to exclude the testimony of Blake Lively's workplace investigation expert Michael Robbins, it need not read any further. On the other hand, if the court allows Robbins to testify, defendant's expert Anne Fromholz should be permitted to provide rebuttal testimony. First, Lively argues that Fromholz's opinions are untethered from the remaining claims in the case. Indeed, the testimony of workplace investigation experts is relevant and admissible, if at all, only with respect to a claim for failing to investigate, prevent, and remedy harassment and retaliation in violation of FEHA. This claim was dismissed, as were all Lively's claims for harassment. The workplace investigation testimony of Robbins and Fromholz is not relevant to the remaining retaliation claim because the duty to conduct an investigation is triggered only by notice to the employer of the alleged misconduct, and the scope of the investigation is determined by and limited to the misconduct complaints that were made. Lively claims that only that she made harassment allegations to Wayfarer, not complaints about a retaliatory smear campaign. Similarly, Robbins' opinion that Wayfarer failed to implement entertainment industry protocols to prevent harassment is irrelevant to the remaining claims. Second, Lively says that some of Fromholz's opinions are improper legal conclusions. To the extent that Fromholz's opinions crossed the line, it is only because she followed Robbins across that line to rebut his legal conclusion that Wayfarer had a duty to conduct an investigation into Lively's claims. The subject of workplace investigation experts is typically confined to whether the investigation that was conducted was consistent with industry standards. Lively's criticism of Fromholz's rebuttal ignores the problems with Robbins's own legal duty opinion. Third, Lively claims that Fromholz's conclusions are wrong, pointing to alleged inconsistencies and alleged failures to consider certain evidence. These arguments go to the weight, not the admissibility, of the testimony and are more properly the subject of cross-examination. Finally, Lively argues that Fromholz is unqualified to testify on entertainment industry intimacy protocols and reputational harm that may be suffered by actors because she never worked on a film set or negotiated a nudity rider. Robbins's work for decades, I know what's coming here. Robbins's work for studios decades ago hardly qualifies him any more than Fromholz to opine on nudity riders and intimacy coordinators concepts that he admits were developed only in the past few years, nor is he any more qualified to address reputational damages in the entertainment industry or otherwise than Fromholz is. Fromholz is an employment law attorney with over 31 years of experience who founded the Fromholz firm in 2015, where approximately 50 to 60% of her practice consists of workplace investigations. She has conducted an estimated 200 or more workplace investigations since approximately 1998 into allegations of harassment, discrimination, retaliation, bullying, and other workplace misconduct, personally conducting 75 to 80% of them. Of those investigations, approximately 10 to 15 have been for entertainment industry clients, including most recently for Warner Brothers, where she investigated allegations of harassment, retaliation, and hostile work environment raised by an actress against a television show's creator, director, and actor on a TV set. Yeah, that sounds like she's sufficiently experienced. She has testified as an expert witness in approximately 20 cases. Fromholz's first opinion rebuts Robin's opinion that Wayfarer failed in its obligation to conduct an investigation into harassment and retaliation allegations raised by plaintiff Blake Lively during the filming of It Ends With Us. She opines that because Wayfarer took immediate action to correct and prevent conduct that Lively complained about, an investigation would have been superfluous. Wayfarer adopted the protections letter, and there's a footnote, Lively proposed, and there was no further unwanted conduct in the second phase of production. So let's see this footnote. Protections letter refers to the document titled Protections for Return to Production, which was sent on November 9th, 2023 by Lively's attorneys to Mizian, Wayfarer's in-house counsel, in anticipation of returning to set after the conclusion of the Writers Guild of America and SAG-AFTRA strikes. Okay. Fromholz's second opinion also rebuts Robin's failure to investigate opinion with her opinion that even if Wayfarer had investigated Lively's complaints, the preponderance of the evidence standard would have led to a finding that most of the alleged conduct did not occur, at least in the form Lively alleged. Fromholz explains that the standard workplace investigators apply is whether a preponderance of the evidence supports a finding that the alleged misconduct occurred or did not occur. Fromholz describes and reviews the alleged harassment incidents as well as Lively's understanding of the original intent to make a sexy R-rated film, in reaching her conclusion that the incidents did not occur as Lively alleges. In her third opinion, Fromholz responds to Robin's opinion that Wayfarer violated entertainment industry protocols which are designed to prevent harassment from occurring. Fromholz opines that Robbins erred in his conclusion regarding entertainment industry-specific intimacy protocols because there was no nudity or simulated sex during Phase 1 of production, and his opinions ignore the intimacy coordinator's testimony and the SAG-AFTRA guidelines. Finally, I'm looking forward to seeing these in more detail further down. Finally, in her fourth opinion, Fromholz opines that Robbins incorrectly concluded that reputational damage is unique to the entertainment industry. She points out that Robbins ignores the numerous other industries in which people develop work opportunities based on reputation, including lawyers, expert witnesses and investigators, doctors, architects, and others. Exactly. To the extent Robbins' duty to investigate and entertainment industry protocol opinions are relevant to the remaining claims, Fromholz should be permitted to rebut them. Because the court dismissed the only claim to which Robbins' testimony and Fromholz's rebuttal might have been relevant, which was the sixth count for failure to investigate, prevent, and remedy harassment and retaliation in violation of FIHA. Robbins' first two opinions and Fromholz's rebuttal to them are thus irrelevant, unreliable, and will not assist the trier of fact. Lively argues that Fromholz's rebuttal to Robin's opinion that Wayfarer should have conducted an investigation into Lively's misconduct claims is irrelevant, but argues Robin's opinion remains relevant. Lively claims Robin's opinion is relevant to her fee-her retaliation claim, but Fromholz's opinion is not. Lively's flawed logic is as follows. Lively contends Fromholz's opinion is irrelevant because it addresses only Miss Lively's complaints made during production, while ignoring anything that followed, including the retaliation campaign. By contrast, Lively says that Robin's opinion is relevant to the retaliation claim because Robin's opines on the failure to follow practices and policies to prevent harassment and retaliation. But as is evident from Lively's own words, Robin's opinions were relevant only to the claim for failure to prevent harassment and retaliation, which were dismissed. The alleged duty to investigate that Robins purports to opine about is not an element of the remaining claims for retaliation. Lively suggests that the fact that an investigation was not conducted may be relevant for some other purpose. That no investigation was conducted is undisputed. Lively fails to explain why Robins's testimony would be permitted just to make this undisputed point. And Lively's own case law clearly says that he cannot. With respect to Wayfarer's alleged failure to investigate, Robin's report and his opinion, consistent with Fromholz's rebuttal, addressed only the reports of misconduct that Lively made during production. The reason for that is obvious. Those are the only complaints Lively made to Wayfarer before she filed her lawsuit. And therefore the only complaints that could have been subject to an investigation. Consistent with the law, Robins testified the duty to investigate is triggered only when plaintiff makes allegations of harassment or retaliation such that the defendant has notice. Once a complaint has been made, an investigation is conducted to determine whether the complaint is justified. Thus, the subject of the investigation is confined to misconduct alleged by the complainant. Lively did not make a complaint to Wayfarer before she filed her lawsuit about the alleged smear campaign. I said this, like she's saying, oh, the smear campaign, it started in August. And I was like, she never contacted them again until she filed her CRD with the New York Times. The California Civil Rights Department. And, how they didn't make a complaint about the retaliation. She did not make a complaint about the retaliation before she filed the CRD. And then a week later, less than 2 weeks later, she's filing her lawsuit. Love it. I'm glad they picked up on that because, when did she go to Wayfarer and say, hey, you're smearing me at any point from August to December? And when Wayfarer were told, they conducted that private investigation that eventually, Lyman said, oh, you can either give her all of the discovery on it, or you can just, not use it yourself. But it was that third-party law firm. So Wayfarer started an investigation when they learned that she was complaining of retaliation, but she never raised retaliation before the CRD was filed, which I maintain it was filed with the New York Times. Lively did not make a complaint to Wayfarer before she filed her lawsuit about the alleged smear campaign, which might have triggered an investigation, and Robbins does not say that she did. The alleged smear campaign, after all, did not begin, according to Lively, until August 2024, months after pre-production, production, and editing had concluded. Yes. Love this argument. When the alleged smear campaign began, the parties no longer had a work relationship and there would have been no reason to report or to conduct an investigation because the purpose of investigating is to address the parties' ongoing working relationship. Yes. And she has herself said that everything that happened from phase 1, it was now resolved. In phase 2 went without a problem. And again, I point to the same thing. Like, after all of that quote unquote alleged, harassment they put her through, etc., she then got through phase 2 with no problem whatsoever, worked perfectly fine with Baldoni. But then her and all the cast very suddenly at the same time needed to take a stand when it came to the marketing, which came months later. In some cases, it had been a year since they'd seen or spoken to Justin Baldoni, and they still felt the need to, like, we all need to take a stand and not appear with him at the marketing because of the way he was, in a totally different year. It's just bullshit. It is bullshit. I'm going to say it as it is, right? It makes no fucking sense. And it is clearly coordinated as well. Okay, this opinion was relevant only to the 6th count for failure to prevent harassment. With this second opinion, there is not even the pretense that these protocols would prevent retaliation, only harassment, which Lively agrees is no longer relevant. Thus, Fromholz's rebuttal opinion that Robbins erred in his conclusion that Wayfarer violated the entertainment industry protocols is also irrelevant. Yes. I really feel like this is coming out swinging, and I'm here for it. Fromholz should be permitted to rebut Robbins' legal opinions. Lively also argues that Fromholz's first and second rebuttal opinions are improper legal conclusions, but Fromholz merely responds to Robbins' legal opinion that Wayfarer had a duty to investigate, which was triggered by Lively's misconduct allegations. The crux of Fromholz's first two opinions are that an investigation was unnecessary, A, because the purpose of a workplace investigation is to address the misconduct alleged, and that result was achieved. Any investigation would have been superfluous. And B, if a workplace investigation had been conducted into Lively's allegations of misconduct, she would have applied the preponderance of evidence standard, and reviewing the evidence, she would have reached a conclusion that the evidence did not support Lively's allegations. To the extent that Robbins' opinions are based on his knowledge and experience as a workplace investigator, Fromholz's are as well, and she must be permitted to offer those rebuttal opinions. I completely agree. I think ideally neither of them are actually needed here, but if Lyman allows Robbins to testify, then Fromholz should definitely be allowed to rebut. Lively also suggests that Fromholz's first two opinions are new arguments, implying that they are not true rebuttal opinions, but should have been made in a principal affirmative report. However, rebuttal evidence is properly admissible when it will explain, repel, counteract, or disprove the evidence of the adverse party. A rebuttal report contradicts or rebuts evidence on the same subject matter as the other party's expert report. The term same subject matter is not narrowly construed. Lively's citation to Recor Systems, Inc. is misplaced. In Recor, defendants purported to designate an expert to rebut plaintiff's expert in financial accounting. However, defendant's expert report did not address financial accounting and instead addressed federal or state regulatory requirements and the standard of a reasonable due diligence investigation in the context of an M&A transaction, matters on which the plaintiff's financial accounting expert did not opine and was not even qualified to testify about. The court excluded defendant's purported rebuttal expert because he was not in fact a rebuttal expert. He was an affirmative expert who was untimely designated. Fromholz's opinion, by contrast, is on the same subject matter, whether Wayfarer had a duty to conduct a workplace investigation. Lively's argument that Fromholz's opinions are wrong goes to the weight, not the admissibility of her testimony, and in any event is unfounded. Lively also moves to exclude Fromholz's first, second, and third opinions, claiming that they are wrong, inconsistent, contradicted, or unsupported by the facts, and or not credible, and therefore unreliable. Lively confuses correctness of conclusions with reliability. A proponent of an expert does not have to demonstrate to the judge that the assessments of their experts are correct. The evidentiary requirement of reliability is lower than the merits standard for correctness. The reliability inquiry is a flexible one. In undertaking this flexible inquiry, the district court must focus on the principles and methodology employed by the expert, without regard to the conclusions the expert has reached or the district court's belief as to the correctness of those conclusions. Lively's various critiques of Fromholz goes to the weight of the evidence, not its admissibility, which means Lively may cross-examine Fromholz with these points, but they are not a basis to exclude her testimony. Okay. Not only does Lively misstate the standard for testing reliability of an expert, her critiques of Fromholz's opinions are without basis. Fromholz's first two opinions are not wrong. Lively claims that Fromholz's first opinion is incorrect as a matter of law because she says it's mandatory under all circumstances for an employer to investigate a sexual harassment claim. But workplace investigations are not legally required in all instances for any misconduct complaint. For example, a claim for failure to investigate sexual harassment must be dismissed if there is no viable claim for sexual harassment. Also, there is no claim for failure to investigate if the employee agrees no investigation is necessary. Lively says that Fromholz's opinion is directly contradicted by the CRD guide, pointing to language that merely says it's rarely appropriate for an employer to forego an investigation when the employee says that they will address the problems themselves. As Fromholz notes in her report, Lively's attorneys, not Lively personally, sent Wayfarer the protections letter with a cover email stating that Lively was willing to forego a more formal process, as long as the set is safe moving forward. Wayfarer accepted the terms, and there were no further investigations of misconduct thereafter. Yep, no further allegations, which is true. Fromholz concludes that this immediate action taken by Wayfarer to correct and prevent the conduct about which Lively complained rendered an investigation superfluous. And also, what's the point? What are you investigating? You know, she's made her complaint. It's been passed on to the people who are subject to that complaint. They've extended an apology, and everything continued absolutely fine. And although it looks on the surface like there were, several incidents, and it's very suggestive that this was over a big span of time. It wasn't. It was over literally a handful of days, 4 days, I think, which were all in very close proximity. So, it's not like where someone thinks that they are being quite innocent, and then they haven't done anything wrong, especially when the offense, no, the perception of the offense is so subjective, right? The person who, in this case, obviously, if you say to someone, "Oh, that dress, definitely it looks sexy," whatever the word is, but you, in your mind, you think that the person who's wearing the dress, because it's a character's wardrobe, and they've already said to you in text message, "I'm going for sexy. That's the look I'm trying to achieve here." And then you acknowledge that and say, and you refer to it as sexy because you are trying to sort of affirm, yep, you've achieved your objective here, mission complete, well done, right? You're not going to, it's not such an egregious offense, right? Where it is clear someone can turn around to you and say, whoa, don't do that again. And no one really did say, don't do that again. You know, by Lively's own complaints and what she says, the steps, you know, what happened immediately after each of these incidents is she didn't actually say anything. She didn't actually say anything. You know, in her way, she was taken aback. Or she said something to Jamie Heath, you know, a couple of weeks later about, you know, oh, I know you weren't trying to cop a look. And like, but all of these incidences, two of them happened on the same day. And if someone if it's not abundantly clear to someone that they need to change their behavior, then nothing's going to change. So, you know, when Ange Giannetti said to Wayfarer, hey, you know, Lively and Slate weren't happy, they got an apology and nothing else went wrong except Justin Baldoni trying to push back against Lively in the, you know, fight over who was going to control the edit of the film. So it's just something to think about. Little sidebar there. It's a thought process because, you know, people, especially Lively supporters, are like, oh my God, all these incidents, right? And it looks like, oh my God, there's a lot happened here. But they all happened on about 4 days. I think we counted them. It was like 4 days. So, okay. Lively claims that Fromholz's first opinion is flawed because it fails to acknowledge what she claims is a core component of investigations. Lively claims that the California Civil Rights Department guide says that during an investigation, a workplace investigator is required to instruct the accused not to retaliate against the complainant. But the CRD guide only recommends that employers, not workplace investigators, inform complainants and the accused that retaliation violates the law. Of course, it's a guideline that Lively's gone, oh my God, they didn't do this. It's the same with the intimacy coordinator, you know. It's a guideline to have what at the time it was a guideline to have them on set. I mean, technically, it still is a guideline, but they have tightened the rules. But at the time, it was not mandatory. Lively wasn't entitled to one, but they had one anyway. Mischaracterizing Fromholz's deposition testimony, Lively claims Fromholz agreed with her proposition. Yet Fromholz testified only that, at the conclusion of an interview, her practice is to tell the witness not to retaliate against others for participating in the investigation, and that the witness cannot be retaliated against for participating in the investigation. She was asked repeatedly whether the admonition she gave witnesses she interviewed was broader, for the accused not to retaliate in future against the complainant, and she repeatedly responded no, that her role is limited to the investigation, so not more broadly, and that she admonished witnesses to prevent or discourage retaliation related to the investigation. As Fromholz testified, it's up to the employer to make a broader admonition as reflected in the CRD guide. Okay. As a footnote, as a footnote here. Notably, Robbins does not offer an opinion that the purpose of an investigation is to advise the accused that they cannot retaliate against the complainant. Therefore, there was nothing for Fromholz to rebut. Also, Lively misleadingly argues that Fromholz admits that because defendants never investigated Miss Lively's or others' concerns, Mr. Baldoni and Mr. Heath were never instructed not to retaliate. But Fromholz did not testify A, that Baldoni and Heath were never told not to retaliate against Lively, or B, that if they were not told, the reason they were not told was because there had not been an investigation. Fromholz was asked if she was aware of Mr. Baldoni or Heath at any time being advised that he cannot retaliate against Miss Lively for raising concerns, to which Fromholz answered, I don't know. In addition, Lively contends that Fromholz improperly reached a conclusion about what an investigation would have uncovered without personally interviewing witnesses and instead relied on sworn deposition testimony. Fromholz testified she regularly relies on written summaries of witness interviews conducted by others in performing workplace investigations. Fromholz also testified that, pursuant to the CRD guide, she assesses credibility by looking at corroboration, contradiction, evasiveness, and those factors set forth in the guide. But Fromholz testified these issues can be gleaned from written testimony. When asked if there is information that you can glean from an interview with someone where you speak to them and ask questions that you can't glean from written testimony. Fromholz responded that demeanor, including the witness's emotional response to questioning, should not be used as a credibility factor. In addition, Fromholz pointed out that deposition testimony is under oath and witnesses are more truthful in a deposition than they are in an interview with me, where it's not sworn testimony. Lively further criticizes Fromholz for allegedly failing to review all of the documents produced in preparing her report. There is no such requirement, nor did Fromholz testify that certain critical data relevant to her opinions did not exist, when it did in fact exist, as in the cases Lively relies upon. Notably, the documents Lively says Fromholz failed to consider were produced only after she issued her November 3rd, 2025 report. Oh, God. Significantly, when plaintiff counsel suggested to Fromholz at her deposition that she might consider this new evidence, Fromholz said she would do so. Fromholz's third opinion concerning entertainment industry protocols is not wrong. Okay, so this is going to be largely about the birth scene. Lively contends Fromholz's opinions concerning the entertainment industry protocols are wrong. Specifically, Lively says Fromholz wrongly concludes the birth scene did not involve nudity, and that Robin's opinion on this point is correct. But Robin's opinion is that the birth scene involved simulated nudity. Fromholz points out that the SAG-AFTRA intimacy guidelines, that's the key word, guys, right? Guidelines, not rules, not constitution, not code of conduct, guidelines. Fromholz points out that the SAG-AFTRA intimacy guidelines apply to nudity and simulated sex. There is no mention of the concept of simulated nudity. Thank you. I've been waiting for someone to say this. Yes, it does not apply. There's no reference to in simulated nudity. It is nudity and simulated sex. Fromholz also opined that the actual trained intimacy coordinator for the movie testified that the birthing scene did not involve nudity, and the SAG-AFTRA intimacy guidelines apply to nudity and simulated sex, with no mention of simulated nudity. Lively ignores this aspect of Fromholz's opinion entirely. Of course she does. She then mischaracterizes the intimacy coordinator Elizabeth Talbot's deposition testimony. When asked if there was any nudity in the birth scene, Talbot testified, "I don't recall any nudity. There was a high hip line that may have been called profile nudity to an extent, and that some actors would require or request a nudity rider for, but that Lively did not request one for the scene." There you go. So what Elizabeth Talbot, the intimacy coordinator, actually said about that entire scene was there was a high hip line, right? She was wearing underwear. Let's be clear about this. She was wearing black knickers. Or shorts. I'm not quite sure. But she was wearing underwear. And what Lizzie Talbot said, look, there was a high hip line, which is sometimes it's referred to as profile nudity. And what that might lead to is some actors may require or request a nudity rider for that. Lively did not. Lively had her nudity rider and was refusing to sign it. And yet she also had in her ALA, she had complete control over scenes. She could veto performing any scenes. I mean, for God's sake, she got the lift thrown out. But yeah, if you listen to Lively, if you look at my videos, literally, she is now saying in her opposition to the motions in limine, in her opposition to Wayfarer's motion in limine, she is saying that she was forced to do this scene. And she's referring to herself as nude, by the way. So honestly, go and check out those videos because that just, I think I lost my ever-loving mind over that. Okay. Yeah. So it was within what this part is saying is, look, some actors, if they're doing this kind of scene, request a nudity rider. So it was within Lively's gift to have that kind of control, and she opted not to. And now she's, basically repackaging it and calling it sexual harassment. Lively also argues Fromholz wrongly faults her for not requesting an intimacy coordinator before the birth scene, relying on Robbins's opinion that it is the studio's responsibility to call the intimacy coordinator to set. But this is contradicted by Talbot's testimony that with a high hip line, it is the actor's responsibility to request a nudity writer. Lively, yeah, exactly, because it's not like a set hard and fast rule. It's like, if you want this, you can have it, but you have to request it. The studio is not going to sit there with a crystal ball or read your tea leaves to work out what you want for something that is an optional element of filming a scene like this. Lively responds that she could not have asked for a nudity rider in advance because she did not know that she would be simulating any type of nudity in that birth scene. This response defies credulity and common sense. She wrote the scene. Like, literally, Wayfarer said she wrote the whole scene. Lively says Fromholz incorrectly concluded the set was closed during the birth scene, relying on Heath's deposition testimony. Lively says that her declaration, filed in support of her opposition to the summary judgment motion, must necessarily trump Heath's testimony and criticises Fromholz for not reading it. However, the Lively declaration was filed after Fromholz issued her rebuttal report and was not part of Robin's opinions. So Fromholz testified she did not have an opportunity to consider the declaration and agreed she would do so prior to the trial. Lively quibbles. Oh my God, they're using my word, quibbles. I love it. Lively quibbles with several other aspects of Fromholz's opinion, but they all amount to her belief that Robbins is right and Fromholz is wrong. This is not the proper inquiry. When, as here, the testimony falls within a range where experts might reasonably differ, the duty to evaluate the weight and sufficiency of the evidence on which the expert relied lies properly with the jury rather than with the trial court. I love that. Okay. Fromholz is qualified to rebut Robinson's opinions about entertainment industry protocols and reputation injury in that industry. Reputation injury in that industry. Yeah, I did say that. Lively argues Fromholz is not qualified to testify about entertainment industry protocols and reputation injury in the entertainment business because she has never negotiated a nudity rider, engaged an intimacy coordinator, or had personal experience with closed sets. I'm loving where this is going because I know what's coming. It's going to be a shitstorm for Michael Robbins. But neither has Robbins. There we go. Neither expert is experienced in the recent entertainment industry intimacy protocols that come into effect only during the past few years, although both experts have conducted workplace investigations for studios. If the court determines that Robbins is qualified because he has general experience in the workplace investigations, then certainly Fromholz is equally qualified. Conclusion. For the foregoing reasons, defendants respectfully request the court exclude the testimony of Robbins, which will moot this opposition. Should the court allow Robbins to testify, Fromholz should be permitted to rebut his opinions. And again, another amazing filing from Ellen. She's doing such a stellar job of all of this. There's so many filings that come from her, and I really appreciate how she goes at them. This was beautiful. I loved it. As always, please do like and subscribe. Really helps my channel. And if you are able to hype again, I would love it if you could do that too. But please let me know in the comments what you think. And if you have any questions, as always, I always try to respond and answer everything and anything. So yeah, let me know what you think and ask any questions. But this, I'm getting excited now because I'm starting to I feel like Wayfarer are not taking any more, bullshit from Lively and her attorneys now, and they are really kind of fighting back, which at this point they really need it now more than ever, because all of these motions will determine how the trial will proceed. So they've got to, bring their A game, which I think they're doing. Some of Lively's motions have also been really quite good. I will give credit where credit is due. At the end of the day, the attorneys are doing a job. They're being paid, whether you like them or not, whether you think that, they've done some really unethical things, and I don't appreciate that at all. But I will, I'll go through it filing by filing. And if I think they've done actually a good job, made some good arguments, or drafted a motion in a particularly good way, I will actually say that. But Ellen is absolutely on a roll, and I love it.